Bill for our consideration is House Bill 143. Thank you. Roll call, please.
Representative Clausen.
Here.
Representative Clifford.
Here.
Representative Duncan is excused. She went to get a shot. She'll be back. Vice Chairman Ayer,
Here.
Representative Hunt, Representative McGuire, Representative Roscoe, and Chairman Zwanitzer is close at hand. Thank you.
Thank you, Madam Chair, Madam Secretary. First bill under consideration today is House Bill 143. Representative Blackburn, are you going to present the bill?
Yeah.
We tried to stop.
Handouts for 199. I did take roll and you are now here.
Representative Blackburn, would I be correct that you have someone who's not here yet who you want to testify in your bill? Okay, Representative Provenza, how would you like to do House Bill 199 up first? Great, come on down. My apologies to everyone. I finally found time to do my quick 5-minute photo that's required for the last 3 days, and but the first 5 free minutes I've had. As Representative Provenza knows, we were both here at 7 a.m. Well, she was. I was here at 7:15 because life. Welcome, Representative Provenza, to present 199 Vehicle Insurance Anti-Stacking Prohibition.
Thank you, Mr. Chairman, members of the committee. I am just getting all my papers together. Please excuse me. Tend to over prepare, I think, these things. Today I bring to you House Bill 199. This is Vehicle Insurance Anti-Stacking Prohibition. This issue is not something that I am very well versed in. I'm not an insurer. I know nothing about it. I haven't read the fine print on my bills, but I will say that I've learned a lot recently on this topic, particularly because I had constituents who came to me concerned that they are in severe medical debt because of car accidents that they had been involved in. They were either one person in particular was struck by a vehicle while they're crossing a road, and they have so much medical debt that they are going to lose their home. The person driving had liability insurance, which in the state of Wyoming is $25,000. That's not enough to cover hardly a Band-Aid in the emergency room. And I had another constituent who was in an accident and also couldn't pay for the extent of their debt. And they're also struggling financially because the person who struck them, the at-fault driver, had the minimum liability of $25,000. So we have this issue of that the liability insurance isn't enough to cover things, but in researching this and knowing that I can't fix our medical care system, one topic that I kept coming on was, even if you pay for higher what is underinsured insurance or uninsured motorist insurance, and some of these I'll define in more detail, even if you pay more in your premiums to get that coverage, you might not factually get that money. So what we end up finding is that, excuse me, in states that allow for offsetting or what we call anti-stacking language in their contracts. Folks might not see in their language that the insurer can do an offset or an anti-stacking provision so that they can reduce the amount covered. So even though they might have more in debt due to medical bills or just damage to vehicles, and they pay for more, they don't get the entirety of what they pay for. So in the handout that I sent to the committee, some of the key terms that are really important here, and understanding why we're here to bring House Bill 199 and hopefully get your support, is that Wyoming consumers are currently being cheated because they fully pay premiums for benefits they only partially receive. Wyoming currently allows insurance coverage offsets, and Wyoming also allows insurance companies to prohibit stacking. So there's some examples in your handouts, and I also was able to make a comic for you today to kind of put this more into perspective of what this ends up looking like. To illustrate how these two problems combine to harm Wyoming citizens paying for insurance coverage they may never receive, I ask you to assume that the at-fault party has the state minimum in coverage, again, $25,000. And the injured party has been paying insurance premiums for $50,000 in underinsured motorist coverage. So that's that UIM on two separate vehicles. And I also ask you to assume the crash caused $100,000 in injuries or damages. And the first chart has shown the offsets and prohibits stacking. So here you see that the at-fault party has $25,000. The underinsured motorist vehicle number one is $50,000. But because of the stacking, the anti-stacking, we find that the underinsured motor vehicle for number two can't be applied here. So the person isn't made whole. They're paid ultimately $50,000 instead of what they could have gotten if, in example number two, then you can essentially add those insurance policies, and then you would have $100,000 in total recovery being made whole. That's essentially, for an example, again, a crash causes $75,000 in damage. At-fault driver has $25,000 in liability coverage, and the insured party has $50,000 in coverage for underinsured or uninsured motorists. If an offset applies, the underinsured motorist only pays $25,000, not the full $50,000 in what should be available coverage, so leaving them $25,000 short. So what specifically is stacking and then offsetting and then anti-stacking? Stacking could apply when is the application of two or more insurance policies to a single occurrence or claim. Stacking could apply when an injured person is paying premiums on multiple vehicles, meaning that we paid for both benefits, but we don't get both benefits. Anti-stacking refers to provisions in insurance contracts intended to prohibit the stacking of multiple insurance policies, even when the insured party is paying for those policies. Offsetting is a term for when the injured party's insurance company is entitled to deduct the full limit from at-fault party's insurance coverage, even if their own insured has not been made whole. So in the example comic that I sent out to folks, you see in number two, the injured party suffers $100,000 in damages, and they're looking at their medical bill and they say, oh man, $100,000. And I paid for, when they call their insurance company, they say, I paid for $100,000 in coverage, and they have $25,000 in coverage, the at-fault driver. So I'm covered, right? I'm going to be taken care of. And the insurance company gets to say, no, that there's an offset of the offsets are $50,000 in uninsured motorist policy is reduced by the $25,000, the amount of the at-fault policy. Anti-stacking, this this coverage does not apply. So they aren't going to stack essentially the policies. But if we can take out the offsets and take out the anti-stacking language, this person can be made whole. So then they get to add these things instead of subtract. So that's why this bill is here before you today. In terms of the language of the bill in House Bill 199, on page 1, lines 8 through 9, we're adding a new section just at the end of Title 26, Chapter 15. We'll insert lines, what would be 26-15-137, stacking of uninsured and underinsured benefits. And on lines 13 through, on page 1, 13 through 15, into 1 through 4 on page 2, this is where we're prohibiting the offsetting. And then on lines 6 through 10, subsection B, we are prohibiting stacking, the anti-stacking. So, and then of course, in section 2, this act applies to motor vehicle insurance policies and contracts delivered, issued for delivery, or renewed on and after July 1st. So this would essentially just let people get what they paid for. And I will try to answer any questions I can.
Okay, let me start with some. Reason we don't actually define the term stacking in the bill, was there any thought that we need a definitional term of exactly what stacking is and isn't? I know it mentions stacking and we even put in the article heading, but.
I'm not sure, Mr. Chairman. Thank you for the question. My understanding is just maybe it's a term that we would understand. You're stacking, you're putting two things on top of each other.
And then do you know if any other states have this provision in their laws? How many do or might?
Yes, we currently, my understanding is that there are 29 states that currently have an offset system. So what Wyoming is doing, 19 states have excess or gap coverage, which would be kind of the opposite, allowing insurance companies to pay more instead of the subtraction. So 19 states would be doing or already doing what we're trying to do here today.
Okay, further questions from the committee? Representative McGuire.
Thank you, Mr. Chairman. And this is maybe a question that, and if the Insurance Commission is here, they might be able to help with it also. So looking through the provisions, the insurance provision in the statutes, I don't see anything that specifically, any language that specifically allows for stacking. So I'm just curious if you could look through and between yourself and the people who are putting this bill forward, let me know if there is language that allows stacking in the current statutes. And also my question is, this seems to me something that would have been litigated. I don't see an annotation to a case. So I'm just curious if it has been litigated before in the state of Wyoming. Thank you.
Representative Prevens, if you know.
Thank you, Chairman, and thank you, Representative McGuire, for your question. In terms of your second question of has this been litigated in the state of Wyoming, I do not believe so. I believe it has been litigated in other states, including, I feel like Montana off the top of my head. And I know there's some folks that are going to testify that could better answer that question. So I don't want to speak out and be wrong. So I would just ask that you, once we have, I think, Mr. Aronowitz, who would testify, and he would have some better information on that. But there certainly has been some issues in other states. I don't believe that Wyoming has, I think I'm just going to pause because I don't know the answer to that. Could you remind me the first part of your question? I'm so sorry.
Representative McGuire.
And that would be if in the current statutory language, if there's permissive language to allow stacking, because typically, well, reading through the statutes, I don't see anything in here in the statutes prior to the one that you want to insert that would allow for stacking. So I'm just wondering if this is the insurance companies being clever and they found a way around the current language, or if I'm just missing it and if there is language in there that allows it.
Representative Provenza, if you know.
Thank you, Chairman, and thank you, Representative McGuire. I do not believe that that language is in the statutes already, so it's not currently saying you can do this. I think it's just something because we haven't prohibited it, and it is something that is practiced that they are indeed doing that. And I wouldn't say that all insurance agencies are, but maybe, some are.
Further questions? Not seeing it at this time, but don't go too far. Is there anybody here from the Department of Insurance or a state agency, either in person or in the room? None of the names in the waiting room look familiar as the state agency. Did you talk to the Department of Insurance, Representative Provenza, and get any thoughts from them?
Mr. Zwanitzer or Chairman Zwanitzer, I think I may have received an email, but I will say I have not spoken with them in detail.
Okay, thanks. You did reference Mr. Aronowitz, so we're bringing him into the room virtually. Mark, welcome to Corporations. Floor is yours.
Thank you, Chairman Zwanitzer, members of the committee. My name is Mark Aronowitz. I'm the Executive Director of Lawyers and Advocates for Wyoming, a nonprofit public interest law firm. And can you hear me okay?
Yep, now we can see you too.
Great. So I started my video. This would be my 13th session in Cheyenne, but here we are. I'm on the Zoom screen, and thank you for making this available. Something I really enjoy in my interactions with the legislature is identifying problems that affect real people and then bringing possible solutions to your attention. And I have been working with Representative Provenza on that. And the problem here starts with the minimum auto insurance policy limit of $25,000. And it's been that number for a long time. And the issue is that when you have that's the limit that somebody has, a lot of times with a serious accident, you could reach that limit on day one of a serious accident with ambulance, life flight, a second ambulance to a trauma center, emergency surgery. You can have $100,000 in medical expenses, within hours of an accident happening. Now, if the person that hurts you only has $25,000 in insurance, the way that we can protect ourselves is with our own insurance policies with underinsured motorist coverage, UIM. And that's what can apply when the other side doesn't have enough to take care of your lost wages or your medical expenses and stuff like that. So you make a claim to your own insurance company and you've been paying, policy premiums for that benefit. And then they can kind of cover the difference between what has happened to you and what the bad guy that hurt you actually has. The problem that this bill is trying to solve is when you don't actually get the full benefit of your underinsured motorist policy. And the first problem is the offsets, which was covered, that let's say I have $100,000 in underinsured motorist coverage. Well, $25,000 will get deducted as an offset because that's what the bad guy had. And it doesn't matter how hurt I am or what my injuries are, that $25,000 is just taken away. And then the second part is it doesn't matter if I have 2 insurance policies that I'm paying premiums for or 3. I can only use one, and that's the anti-stacking part of things. And to answer Representative McGuire's question, stacking versus anti-stacking, it isn't really in statutes, it's in your insurance contract. So if the insurance company says, here's 40 pages of your policy, and on page 37 says, we do not allow stacking, you sign up for your insurance that you have to get. And most people are never, ever going to read that, or even if they read it, know what it means. And now you have agreed to anti-stacking. However, if the statute says anti-stacking is not allowed, then the insurance companies won't be able to do that anymore. It has been litigated. It's been litigated in state court. It's been litigated in federal court. I can get you the case names if you want. And the courts usually just have to go into great detail about what the insurance policies say to determine whether it's clear and ambiguous about whether stacking or anti-stacking is allowed. And they're usually kind of complicated and tortured opinions. And HB 199 would be great guidance for that. And so two main thoughts, and then I'll wrap things up. You will likely hear at some point that if HB 199 passes, insurance prices are going to go up, and they're going to go up 75 to 500% or some wild range like that. Even if you hear that, we are only talking about one small part of an insurance policy, the underinsured motorist part of it. We're not talking about the entire policy. So I'd like to walk you through my own policy just for a minute so you could see how these numbers actually work. I have a 5-year-old Jeep. I pay $46 a month for the coverage on my Jeep. I pay $46 a month because I carry $250,000 in liability coverage. If I ever hurt someone with my vehicle, I want to make sure that they are taken care of. So I carry the 10 times the state minimum as a policy choice. To do that cost me $12 a month. My property damage coverage is $2.50 a month. My uninsured motorist coverage is 90 cents a month. And that's so low because the law says you have to have insurance. So most people will have at least the 25. And my underinsured motorist coverage at $250,000 is less than $7 a month. So even if that doubled, it would be $14 a month. So, and I have a higher policy because if my family or I ever get hurt, I want that $250,000 to pay for life flights and surgeries and medical expenses. So that's a personal choice. I would rather pay $14 a month and get the full $250,000 I'm paying for than $7 a month and not get it. And finally, you may hear that this is a lawyer's bill. It's a trial lawyer's bill. Lawyers want to make more money. And frankly, I think this bill is the opposite of that. People do not call lawyers when they feel like they have been treated fairly and when they feel like they're getting the benefits that they paid for, or when they are able to pay their medical expenses or cover their lost wages. People call lawyers when they feel like they're being ripped off and they're not getting the benefits of what they are paying for. So I would hope that if HB 199 goes through the process and becomes law, there's going to be less people calling lawyers saying, I have to declare a medical bankruptcy. I can't cover my debts because their insurance policies will cover what they've been paying for, and they'll have what they need to take care of themselves. So I'm happy to stand for any questions, and I'm really thankful for your time and for your consideration of this bill.
Thank you, Mr. Aronowitz. And did you identify who you were with, or are you representing a group or industry today?
I'm the executive director of Lawyers and Advocates for Wyoming, so it's in that capacity.
Questions, Mr. Aronowitz? Representative Ayer.
Thank you, Mr. Chairman. Mr. Aronowitz, if you know, could you give me an estimate or on the number or percentage of vehicles on our roads that are either not insured or insured at only the minimum amount of 25,000?
If you know.
Yep, Mr. Chairman, Representative Ayer, I do not know those numbers off the top of my head. I think very few people are uninsured because that is breaking the law, and you get pulled over, you'll get cited for that, you'll be in trouble. I have no idea about how many people choose the minimum, but it's going to be a pretty good number, just because when you're offered the cheapest option, a lot of folks will say, yes, I want that.
Further questions,
Thank you.
committee? No, Representative McGuire, go ahead.
Thank you, Mr. Chairman. So I guess that I'm at first blush as I read the proposed bill. So it says that provides for an insurance policy that provides for uninsured or underinsured motor vehicle coverage. So let's use your example with underinsured. Well, doesn't the insurance company have an opportunity to litigate how much fault there is in an accident? So let's say that you're in an accident with someone who quote unquote is underinsured. Maybe they've got $25,000 of insurance, but they're only 1% at fault. Doesn't that insurance company have an opportunity to litigate who's at fault and how much will be paid? Whereas the bill, as I read it, says policy limits, and I don't see the opportunity for the insurance company to try to make themselves or to protect themselves or their client. Thank you.
Mr. Aronowitz, if you know.
Chairman Zwanitzer, Representative McGuire. I don't believe this bill intends to or interferes with the insurance company's ability to defend themselves and contest liability or what the damages are. Often by the times you're getting to an underinsured motorist discussion, the liability of the other party is pretty clear, and so are the damages. You would rarely progress to that step if the underlying liability was in dispute. And then the underinsured motorist carrier, your own insurance, if you're the hurt person, they are involved in that process and they get to consent to whether you settle with that first party. So they do have rights that we have to be very careful of protecting, or we can kind of screw up the whole thing.
Okay, further questions? Not seeing any right now, Mark. Thank you for being here.
Thank you.
Committee, we did find the insurance commissioner. So Mr. Rude, I see that you're on. I don't know if you heard any of the testimony, but certainly if you have any numbers on how many uninsured motorists or underinsured motorists we may have in Wyoming.
Mr. Chairman, committee members, Jeff Root from the Department of Insurance. Unfortunately, we do not. It's something that we don't track. We review all the policies, but we don't know what an individual policy would contain.
Also, maybe if you could comment, have you had complaints to the Department of Insurance on stacking provisions or anti-stacking prohibitions, however you want to phrase it? And have you researched or done investigation, or what would be the process now should a complaint come in? How would you handle that?
Mr. Chairman, I'd asked some of our folks in the office when this bill came out if there had been any concerns or problems. I'm not sure how far back, but at one point we actually passed a rule that would say that if the contract is silent, that stacking is allowed. And what that led to was clarity from the insurers. They would all say that, they would all specify in the contract that stacking was prohibited. And so we only would probably receive an inquiry once, twice a year at most.
Okay, does the department have any other thoughts they want to share or comment on regarding the bill? Other states do it, any concerns?
No, not really, Mr. Chairman. We're neutral on the bill. It'll either be there or it won't, and we'll continue to inform consumers accordingly.
Committee, any questions for the Department of Insurance? Representative McGuire, go ahead.
Thank you, Mr. Chairman. So same question before. Is there permissive language in the Wyoming statutes that allow stacking?
Mr. Root?
Mr. Chairman, Representative McGuire, are we referring to currently in statute or are we referring into the proposed bill?
He means currently in statute. Any provisions or rules or regulations?
Mr. Chairman, currently in statute, stacking, we would interpret stacking being permissible unless specifically prohibited in the actual insurance contract.
Okay. Seeing no further questions, thank you very much, Mr. Root, for joining us.
Thank you.
Just so I can get an idea of anybody on Zoom who wishes to testify on this bill, if you'd raise your virtual hand. I see one. We'll let Mr. Soloff in. And then I believe we have 3 or 4 people here in person to testify. With that, Jeff, welcome to the Corporations Committee. Testimony you want to provide on House Bill 199. You're live.
Took a second. Thank you, Mr. Chairman, committee. Jeff Suloff, I'm with Mountain West Farm Bureau Insurance, Wyoming's only domiciled PNC insurer based out of Laramie. Yes, we are aware of this bill, and for the committee's knowledge, our company operates in Wyoming and Montana, and stacking is allowed in Montana. So this is something that we do have a considerable amount of experience with. You know, this bill, essentially, I would disagree with maybe some of the other comments that were made in that the coverages that are provided under the insurance policy are based, are what a consumer would pay for. And as the commissioner just stated, stacking in certain circumstances, without getting into too many technicalities with that, is allowed currently for underinsured coverages in Wyoming. However, companies are able to provide the products or have some, I guess, discretion on the products that they offer, both in the amount of coverages that they offer and obviously the price to the consumers. So individual companies may often put anti-stacking or prohibit stacking, anti-stacking language in their policies for purchase. So with this, you would be impacting a large number with the passage of this bill. You would be potentially impacting a large number of consumers' policies. I don't want to butcher his name because Mr. Aronowitz did mention that, yes, you will hear from a rating standpoint that rates would increase. And the figures are high for the particular coverages that are offered. And this is the percentages that he mentioned, 75 to 500%. Those are accurate figures, and he is correct that it's based upon just the or the UIM coverage amount. But let's keep in mind, if this is made across the board changes, you're going to rate generally each vehicle that is charged a specific rate. Those rates are going to increase as well. So there's a multiplication effort for those families that may have more than one particular vehicle. There is coverage out there. And I mentioned this earlier in that it's the industry's feeling that they receive the benefits that they are purchasing under the contract. If they provide or they want additional benefits for or UIM coverages, the market has many opportunities to go and purchase additional coverages out there. There are products with significant limits that may exceed what a primary carrier's limits would be. There's just products out there that they could purchase. We are making the assumptions, and I wish I had some figures for you exactly what percentage of Wyoming drivers are uninsured or have the state minimum limits. I do not have that. I believe our limits profile from our company standpoint is much greater than minimum limits, but there are companies that's all they sell. So it's really hard to get an accurate, I guess, figure for you, unfortunately, on what percent are maybe uninsured and what percent are underinsured or have the state minimum limits. But the bill essentially is making a few assumptions that many people have underinsured or have state minimum limits, which is not necessarily the case. with this, another point that was made, this does, there is the possibility with increased limits in this, in the UIM realm, can increase the amount of litigated claims. Because this gets into a discretion just much like with standard liability limits of how much is an injury worth. And so with that, it may increase the amount of litigated claims that are going through the court system. It has in Montana. We have more cases on this. And the current consumers do have protection right now if a company, an insurer is not treating them fairly. They have the protections to make actions against the company. And finally, there is some language, I believe, that would need to be clarified in the bill itself. Currently, UIM coverage is a discretionary coverage. It is not required to be offered to consumers. coverage is. So there is a discrepancy within the bill itself. With that, Mr. Chairman, I would welcome a few questions.
At least a few, huh? Let me ask you a couple then. So it would be fair to say that you write contracts differently in the state of Montana than you do in the state of Wyoming in regards to these provisions when it comes to stacking.
Correct.
Any detail you could give us? Montana and Wyoming, you know, we're rural states, relatively same demographically. Can you, if you know, or if you can hypothesize what the difference in the average insurance coverage amount that you charge to, in regards to the stacking provisions being in place in the other state? Are we talking a 2% or covered policies 5% on average more? Do you have that information?
Well, for the individual coverages, yes, ironically, prior to this meeting, the 75 to 500% is actually Mountain West experience in difference of rates for the particular coverages. 75 up to 75% per vehicle for coverages, and up to 500% more for UIM coverages is the difference in premium between Wyoming and Montana. Now I'm giving a large range there. Obviously, you know, there's some proprietary figures with that, but that's on average what consumers could see.
Got it. So statistics can be scary. So on average, what's the, you know, the average car on the road? I think last I looked was 9.5 to 10 years old. What's the standard? Is it $4 a month? Is it $30 a month that you pay for uninsured motorist or underinsured motorist?
I could get that information. I honestly, that's not necessarily my area of expertise, but we, you know, there's an actuarially sound rate that's calculated based upon the company's exposure and the likelihood of loss and the experience from loss. So those factors play into rate differences. You know, you're going to be receiving more premium, you're paying more in claims, and that's how things you know, would end up being priced.
Makes sense. If we're talking a 500% jump in $4 versus a 500% jump in $40, I can certainly see how that would become. Maybe one more. Does your organization have a kind of recommended number for uninsured or underinsured motorists when you're issuing policies and talking to prospective clients? Do you say, hey, here's the minimum, but here's what we'd recommend? Is there any policy in place on what you recommend for drivers?
Yeah, I believe that our standard offering is $100,000 in coverage, but they can purchase more.
Thanks. All right. Sorry for asking so many questions. Committee.
No.
questions with the Mountain West Farm Bureau? I'm not seeing any more, but thank you for indulging all of mine, Mr. Suloff.
Thank you.
I don't see anyone else on the internet. People here, Miss Wilkinson, come on down. And Mr. Suloff, I'm going to leave you in the room. Just turn your video off so the YouTube world doesn't have too many pictures on the screen. Welcome, Catherine, to Corporations.
Oh, there we go. All right, got it. Thank you. Mr. Chairman, members of the committee, Catherine Wilkinson, here today representing American Property Casualty Insurance Association, standing in opposition to the bill. Just briefly, Mr. Chairman, I'll give you an overview, and then I do have a few answers to some of the questions. We do stand in opposition to the bill because with this it would create more coverage, but it's also creating, you're going to have to pay for that extra coverage. It's taking the choice away from Wyoming people who want to buy the insurance, and they're going to, with more coverage, the liability is going to go up because you're stacking it. So the policies are going to go up because the coverage goes up. So you're going to mandate that Wyoming citizens do need to buy more insurance. So again, in opposition to the bill, in terms of some of the questions, right now, there's nothing explicitly in Wyoming law that prohibits intra-policy stacking, so within the same policy. But anti-stacking provisions and policies have been enforced by the courts as long as the policy expressly states that the only one limit applies for uninsured or uninsured and underinsured motorists. There is some case law that I have for you. Commercial Union Insurance Company versus Stamper. The site on that is 732 P2D 534 Wyoming 1987. Also followed by Aaron versus State Farm Mutual Insurance Auto Insurance Company 2001 Wyoming 112. It's 34 P3D 921. 2001. And the holding in that case was anti-stacking provisions in insurance policies are not against public policy, where the insurance policy expressly stated that stacking was not permitted. The stacking of an insurance coverages under a single policy covering several vehicles was not allowed. So the majority of states too, Mr. Chairman, do not permit intra-policy stacking, or they might permit it, but they allow the insurers to include the anti-stacking language. So basically, in summary, Mr. Chairman, we feel that Wyoming drivers can already do this today by purchasing higher limits if they want to, and that we shouldn't be mandating them to do that. So this restricts their choice. Let's see. Sorry, Mr. Chairman, not an expert in this area, so trying to follow the talking points on it. I will tell you, I do have a white paper that the data on it is a little bit old, but from the National Association of Insurance Commissioners, NAIC, those favorite bills that come by. For one claim for a group of states that do permit stacking, it was significantly higher than those that prohibit it. And the example that was given, again, this is dated information, I believe, from 2011, but it would be $26,000 per claim if they permitted the stacking as was recommended in this bill versus the $17,517 per claim with no stacking. So with that, Mr. Chairman, I would attempt to answer any questions that the committee may have on it, but we do stand opposed to it, mostly because of the mandated contract interference. So thank you, Mr. Chairman.
And I just want to make sure stacking is based on the number of vehicles you have on your policy, not the number of people you have insured. Would that generally be correct?
Mr. Chairman, I believe that's correct. So yeah, the intra would be all the vehicles in one policy. And so this bill would be if you had 3 different vehicles and they each had 100,000, that they could stack that for each vehicle on there. But then the cost would also reflect that if this were to go through. It would also cost a lot with rewriting all of the contracts and the paperwork as well.
And then the APCIA in general is a trade organization representing a wide number of property casualty automobile. So in all of those members, I don't know if it's appropriate to ask this or not, but let me know. Do any of those car insurance companies who are members have specific, do they all allow different policies based on what state they're operating in that have stacking provisions? Have any of these insurers taken specifics in regard to anti-stacking, or they always will allow except in states that I'm trying to get where the industry is. If I'm competing for car insurance, have any of the car insurance companies that do you know specifically, are they allowed except in states to prohibit it, or do any have policies that we never stack? Any idea?
Mr. Chairman, I believe that it's company-wide, policy-wide. But I will tell you, depending on the state, and again, this is a dated information. I can get you updated if I can't, if you would like follow-up. But as I understand it, so 17 states permit the stacking for coverage for all policies. 22 states don't allow any stacking at all. And then 12 states permit either inter-policy or intra-policy stacking or both. So I think that unless it's specifically prohibited of adding that up, I think if it's written in the policy, that is what the majority of insurance companies do. But again, it's policy by policy because it's a contract.
So on that map, Wyoming is, we're one of the 12 states or one of the 27? Because we're silent. My understanding is we're silent basically in law and rule and regulation. So we come down as being an allowability to have, or well, it just, sorry, when it's the anti-stacking prohibition, right, it's double negative. So I'm always saying it wrong. We do not allow stacking, or insurance companies or in their policies specifically state they will not stack. Does that make sense? Is my question. Where are we on that state map?
Mr. Chairman, the double negative gets me too. So hang on, let me refer my notes. So with Wyoming, there's nothing that says that you can't stack the policies in your own policy. But there's anti-stacking. So you can't add them up, have been enforced by the courts as long as a policy states that only one limit applies for the uninsured or the uninsured. I'm sorry, Mr. Chairman, I'm not sure if that answers your question.
I'm getting there quickly.
Mr. Chairman, I have one other follow-up, just due to conflicting committees. State Farm also stands in opposition. So speaking on behalf of Ms. Shaner as well.
Just waiting for the day to disagree. Representative Clausen.
Thank you, Mr. Chairman. Just a quick question. I'm thinking about an informed consumer component of this. So is there like a disclaimer? My thought is you compare two insurance companies, one's actually cheaper, but you think you're comparing apples to apples, but one of them has an anti-stacking clause. Is there some sort of a disclaimer? How's the consumer know?
Ms. Wilkins, if you know.
Mr. Chairman, it would be in your policy, in the policy language that you get when you buy insurance. So it would be in there in terms of comparing it, between two different companies. That's where you would find that information.
Would it be correct? I'm just assuming that most times when you go shop for car insurance and you talk to your agent, the conversation around stacking doesn't come up. They said, here's all the policy language. You're welcome to read through it. But when you're going through coverages, the words stacking, do you want extra uninsured motor? I know you don't do this for a living, but it never came up in my conversations with my agents. I'm sure it's in the fine print somewhere. But if you know of any who's expressly say, hey, there's just an issue called stacking, and we want to say, here's a minimum coverage, but you might want more because of how the world works. Have you heard of any of your current companies expressly talking about that when talking to people to be insured?
Mr. Chairman, I have not, but there is a gentleman in the back of the room that does represent agents. I'm sure he has an answer, but Mr. Chairman, I would assume that if this law does pass, that it may come up in the future.
Representative McGuire.
Thank you. Two items. First, if you don't mind, could I get that second citation? I wasn't able to write quickly enough. It's 112 p.s, I think.
Yes, Mr. Chairman. So the first one was, it's yes, 112, 34 P 3D 929 Wyoming 2001. And that was Aaron versus State Farm Mutual Auto Insurance Company. And then the other one I have, I believe I only gave you the two. The last one, Mr. Chairman, is Mina versus Safeco Insurance Company, 412 F3D 1159 in the 10th Circuit in 2005.
And one quick follow-up. And this, some people may smile, but I generally don't monkey with people's bills. But both of you may want to take a look at page 1, line 13. The last word in the line, so the limits of coverage available for a person. Keeping in mind that now that the term of art person is also being used to cover entities. If I had an entity that had 30 vehicles, if you look at the next line on page 2, be the sum of the policy limits for each motor vehicle. Well, suddenly the stacking could get really crazy, especially if you have a larger entity. So I would just, it's up to the two of you, but that would be something that I would certainly, that would raise my eyebrow if I were in the industry. Thank you.
Representative Bear.
Thank you, Mr. Chairman. These double negatives keep me confused as well. As I read this in paragraph B, it would require stacking. I know it just not only would allow it, but it would require stacking. Are there any other states that require stacking?
Ms. Wilkinson, if you know.
Mr. Chairman. Mr. Chairman, my language is also Representative Provenza may have more updated numbers, but I believe that there are 17 states. I think she may have referenced 19 that do permit it of the uninsured, underinsured motors coverage for all policy.
Permitting is different than requiring.
Oh, Mr. Chairman, that's correct. I will have to get back to you on that.
Okay. Further questions? Welcome back, Representative Duncan. Seeing none. Thank you very much, Ms. Wilkinson. Ken, you were referenced, so I might as well bring you up next if that works. And I'm going to try committee in the next 10 or 15 minutes to get to the next bill, so. Welcome, Mr. Houck. Always a pleasure seeing you.
Thank you, Mr. Chairman. The microphone is on, I guess. Mr. Chairman, committee members, thank you for taking the time to discuss this bill. We only have a few more pages to discuss. You smiles, I know it's a tough day. So I'm going to share a few things with you, and then I will, I do have some data, and I do have some other points that I want to make. My name is Ken Houck. I'm the EVP of the Association of Wyoming Insurance Agents, commonly known as the Independent Agents. The title of this bill does have two negatives in it. Two negatives don't always make a positive. In this case, they certainly do not. And the bill is way more complex than its two paragraphs would lead you to believe it is. Way more complex. We as an 11-member board with a combined, well over combined 250 years of insurance experience, plus my 48 years, we all conclude that this bill as written, we cannot support. We believe this bill will have an unexpected financial consequence to insureds. It's been addressed several times, and the uninsured and underinsured motorist premium will go up. And I'll talk a little bit more about that in a bit. We also believe that this limits consumer choice, and some of you have caught on to that a little bit. Talked a little bit about that. It will limit consumer choice the way it's written. We believe this bill is actually not even congruent with the Wyoming financial responsibility law because it throws some extra things in there that weren't really conceived probably. There is a concept though, however, buried into this bill that is something that we believe merits for the discussion. There is a section in there and there's been some discussion about that. This bill is really actually a very important discussion to be had. And it probably requires a little bit more than a short committee meeting where they're walking into these conversations blind and don't know what a UM or UIM is. But I would think it would deserve more discussion. So according to the Insurance Research Council, which is a division of the Institutes, which is one of the oldest and most prestigious insurance education training think tank part of our world, goes back to the 1940s, 13% of the drivers nationwide, about 1 in 8 have no insurance. 13% nationwide. In Wyoming, that number is 8% of the Wyoming drivers, about 1 in 12 drive uninsured. Somebody may drive down into Colorado from time to time. In Colorado, it's 13.2% that are uninsured. Per the US Department of Transportation, in 2017, Wyoming had the most registered automobiles per capita in the country. 1,140 registered automobiles per 1,000 residents. We like our trucks, we like our SUVs, and I'm pretty sure some of you guys have some trucks and SUVs parked out back at the barn that haven't been registered for years because they never leave your property. There's a lot of that. In Wyoming, 8%, okay, 8% of that number is about 55,000 uninsured automobiles in Wyoming. That's significant. An anecdotal story, had an insured customer years ago when I lived in Casper. The insured had 4 sons. They all had cars and they all were hit by an uninsured driver that summer. One summer, all 4 of them got it. So, you know, it's kind of like the old joke about tornadoes in mobile home parks. Well, uninsured motorists and accidents kind of fall in that category as well. Of the 92% that are insured, you've asked this question before, many have minimum limits of liability, which is $25,000 per person, $50,000 per accident, and $20,000 property damage. That's the Wyoming statute. So many people do it. My best guess, and there's probably no way of doing that unless you look at all 600,000 policies that are written, but my best guess is that number is 40%, give or take a little bit, that would have minimum limits because that's all that's required. And I even know an insurance company that their motto is, we'll keep you legal, which means we'll say the minimum limits and that's all we sell. So there is some of that. So they do that just to comply with the law and don't care to buy more, okay? So why does uninsured motorist exist? Well, again, 8% of the Wyoming registered autos do not have insurance, 13% around the country. One state, I think the number was 25% do not have insurance. Why does underinsurance or UIM, underinsurance motorist exist? Possibly, again, 40 to 50% have minimum limits in Wyoming. And as has been said before, a day in a hospital is going to cost a lot more than $25,000 these days. Okay. So the minimum required, again, is $25,000 per person, $50,000 per accident, $20,000 property damage. And again, that's just way too low for a day in a hospital. It's also way too low to replace an average, not too old of a car. I mean, you can't buy too many cars for $20,000. So this bill is an important discussion, no question about it. But the bill as written is not the solution. It attempts to fix a couple of issues, but it creates a few more in the process. So we would like to offer a few thoughts. A suggestion, first of all, this is just a suggestion, but I wandered through the Wyoming insurance statutes in Title 26, and I couldn't find a lot of reference. I didn't have a search tool, but I couldn't find reference where uninsured motorists was actually dealt with, and finally figured out it's sitting in Title 31 motor vehicles. That's where the financial responsibility law is. That's where they talk about uninsured motorists. So I might suggest it might have a better fit either there or another section in the Wyoming or the Title 26, because the chapter that it's in is about 20 pages of life insurance discussion, and then it's tagged at the end. So it's probably not a good place for anybody to find it. So Chapter 10 of Title 31 is entitled Uninsured Motorist Vehicle Coverage. Underinsured motorist vehicle coverage is not mentioned because that is not a statutory thing. That's more of an evolution of a process that has occurred over the years. So statute 3110-102 requires uninsured motorist coverage in Wyoming. But it also allows for rejection. It gives the consumer a choice. So the consumer can reject it. That statute also refers back to some definitions in 31.9.102, a Romanet 10, if you want to look for that. So that's our first suggestion. Second is with a simple Google search, like everybody else probably did, I found some information, and we have different numbers, so it could be different years, but the accuracy of the numbers is probably fairly certain. I found my information on, I think it was Allstate's website, actually. 22 states allow stacking of limits. I didn't see any reference to any states that mandatorily require it. Okay. I found that, interestingly, that surprised me, really surprised me. I have to say, I have not sold an auto insurance policy for about 20 years. And so I just never paid attention to what the evolution of the auto insurance world has become. And that surprised me when I saw that, because of a couple things. I believe the entire concept has a flaw built into it. And I'll explain that momentarily. 10 states, according to the information I had, only allow stacking if you have multiple policies in your name. Several major insurance companies in Wyoming sell one policy per automobile. So that would apply then if we had such a law, that would apply. But many companies place all their own automobiles, all the owned automobiles on one policy. So then that wouldn't apply. So there's another flawed concept. Why would you say it has to happen over here, but it can't happen over here? And that's a flaw in some of the other states as well. So we want to make sure we never reach into that world, because that's confusing. So the third item we want to talk about is offering uninsured motorist coverage and minimum limits. That's the uninsured motorist coverage and minimum limits is required in Wyoming. Offering it is required. The insurance and the insured can reject it. And that has been the law for as long as I can remember. Common practice is that the state insurance commissioners, insurance department is created a form. That form is followed. You sign off. If you don't want it, you sign off. If you keep it, that's fine. But if you don't want it, you can reject it in writing. If this bill were to go forward, under any circumstances, we believe allowing for a signed rejection form would be mandatory for stacking of uninsured motorists as well. And there's a good reason for that. And you've been introduced a little bit to it, and I'll bring it up again. And it could be incorporated simply in the form that is used today. And I've seen other states where allow stacking. They have the rejection form for both coverages right on the same page.
Would it be fair? I just need you to. We have another bill after this, so it's fair to say that AIA is not in favor of the bill this time. And yeah, go ahead and close this out.
Okay. So there's a couple things that give us the heartburn. The word shall appears twice, clearly. That doesn't allow for rejecting. I'll tell you, I'll give you a real dollar sign on allowing stacking. My personal auto policy, I have two autos. The underinsured motor premium is $160 for the year. If I were allowed to use double the limits, it would be around $320. We're not talking about what the monthly is, we're talking about the annual. It may double. If I had four vehicles, and that's been alluded to before, there's a problem there. Fleet vehicles, a huge problem there. So closing, each line of coverage on an automobile policy is priced by itself. Automobile policies are sold by car, not by policy. So when you're trying to do stacking or other things of that nature, then you're trying to get twice the coverage for the price that you paid for it. Okay. From my perspective, then stacking limits is really kind of akin to going to a price fixed banquet, and then when you get to the dessert, you want two desserts for the same price as you paid for the one. But we do think there's merit to allowing or working off that offset of offsetting from the party that it's at fault. We think there's some merit there, but I don't think we can work it into this bill. Mr. Chair, I stand for any questions.
Questions, Mr. Houck? Not seeing it right now, but thank you for that information, Ken. That's exactly what I wanted. On about 15%. Other people wish to testify for or against this bill, Mr. Moline? Not the same Farm Bureau, huh?
I'll explain that briefly.
I know. Welcome to corporations.
Thank you, Mr. Chairman Committee. Brett Moline on behalf of Wyoming Farm Bureau Federation. We are not affiliated with the Mountain West Farm Bureau Insurance. We are two separate entities. Testifying on and against this bill, looking at the cost that this could have to my members that are engaged in production agriculture. $2-3 a month per vehicle doesn't sound like much to some, but some of my members can have 10, 15. Some members have 20 vehicles. So the added cost can be quite a bit in a business that in the last few years has not hardly been profitable at all. And I will, so against the bill because of the cost. I would also like to push back a little bit on the comment that was made that you don't get an attorney until you have to have one. Most of my members that are engaged in a business have an active relationship with an attorney because of being in a business. They understand the necessity of that. And in many of the, even if it's a sole proprietor, they will have some type of relationship with an attorney just because in today's world it is a necessity. With that, Mr. Chairman, I tried to be as brief as possible, kind of against my character. But with that, I would sit for any questions.
Questions for Mr. Moline? Seeing none at the time.
Thank you,
Thank
Mr.
you very
Chairman
much.
Committee.
Anyone else wants to testify for or against the bill? Ms. Shaner, Ms. Lance, you're good? All right, we'll close. Let me make sure one more time there's no one jumped up on Zoom. Nope. So committee, we will close public comment. What is your pleasure on House Bill 199? Representative Clifford.
Thank you, Mr. Chairman, and just thanks to the bringer of the bill. And what I heard in discussion, it's probably not ready, but I would probably urge maybe to put it as an interim topic and continue the discussion and look at everything. So that would be my suggestion.
Did sound like Mr. Hauk wanted to spend some interim time hanging out with the corporations committee this year. I think we're the best fun committee to hang out with all year personally. So still asking for a motion on the bill, but entertaining public comment or committee comment. Should any committee member want to say anything? Looking for a motion to bill one more time. Moved by Representative Roscoe. Is there a second? Second by Representative Clifford. Okay, bill's on the table. Any amendments or discussion, committee? Representative McGuire.
Thank you, Mr. Chairman. Just as a matter of discussion, I would agree that this would be a great interim topic. And if it does come as an interim topic, I would recommend that it be a very narrow topic. Insurance is obviously a highly regulated and highly contested item. And in my opinion, it's best if you take a small bite at that apple and deal with one item and then move to the next. Because there's a lot of things that if I were king, I would change about our insurance. But it's every time you make one little adjustment, 20 other things change. So that would be my comment. Thank you, Mr. Chairman.
Thank you. All right, seeing no further comment and question being called by someone. Barb, if you'd call the roll on House Bill 199.
Representative Blackburn. Representative Clausen. Representative Clifford. Representative Duncan. Vice Chair Air. Representative Hunt. Representative McGuire. Representative Roscoe. Chairman Swanitzer. 3 aye, 6 no.
Well, Representative Provenza, we all have days like this in the legislature. And for those of you who weren't in judiciary this morning, it's one of those days. But I do think it's an important issue. 17 states allow it. Certainly something I will recommend in our interim discussion that we should take a look at with other insurance issues that will come before the committee that aren't redistricting. And so maybe there is a middle ground that's not as extensive that we can all, go towards. So certainly appreciate you bringing the bill and look forward to seeing you in the next one. Thank you. Next up committee will be Representative Blackburn. He's going to be presenting House Bill 143 Municipal Services Recovery Actions. He's going to sit as far from me as he can, apparently. Hi, Representative Blackburn.
Would you like me to sit over there?
No,
Mr.
you're good. Welcome to Corporations 143.
Well,
Floor is
thank-
yours.
Thank you, Mr. Chairman. I'm glad to be here. I'd like to present to you House Bill 143. The purpose that we brought this bill was to have people that are using the water, sewer, and garbage pick up in their respective towns and cities to pay their own usage their own way. So I'll just real quick walk you through the bill. It's a pretty small bill. Section 1, we're creating Wyoming statutes, and A is basically cities and towns cannot collect or attempt to collect past due bills from property owners that are not contracted with them. And Section B is the property owner is not required to contract with the city or town when not living on the property. Section 2 of the bill, it doesn't modify or impair or change or cancel any type of a contract that an owner might have with the owner in the city. Section 3 is an effective date of July the 1st, 2021. And I'll stand for any questions, Mr. Chairman.
Committee, questions for Representative Blackburn? Representative Duncan.
Representative Blackburn. Oh, thank you, Mr. Chairman. Representative Blackburn. Can you tell me why this bill? Because my community, they collect deposits and they actually go after. So why this bill? Because we have new people on this committee and they don't know the history of this.
Sure, Representative Blackburn, any extra history you'd like to provide?
Mr. Chairman, thank you, Representative Duncan. The reasoning for this bill is because some towns and cities do not collect a deposit. They go right after the landowner without any deposits from renters or leasers of the property. So they hold the property owner responsible for that bill. I hope that answers your question.
Further questions? Seeing none at this time, Representative Blackburn, don't go too far. People here in person to testify on House Bill 143. You're here to
Mr.
testify in person, Representative Duncan?
Mr.
Well,
Chairman,
Representative Blackburn?
I believe I have some people on Zoom.
You do. I just thought I'd do in-person comment first. And so please welcome Representative Duncan to speak on behalf of the bill.
Thank you, Mr. Chairman. Mr. Chairman and members of the committee, the real necessity of this bill is that actually there are some communities in our state that the neglect of the city for, I'm not sure why, however, that I don't know if they don't have the staff, I don't know if they have the software, the capability, but they will actually allow tenants to move the tenant will move and then a new tenant will sign in, and they allow those tenants to create debt and pile up and pile up and pile up, and they won't follow that tenant. And so then the debt continues to grow against that property, and then they will go after that landlord for a huge debt, and they don't actually follow that tenant when the tenant is actually the one that is on the hook. And so that landlord ends up having to pay a huge deficit. And that's what's going on. And I don't understand why these cities can't create this deposit system. The capital city is actually one of those cities. Whereas my city, they actually require a deposit, and they do, they used to do a average over a 12-month period. And now they do the highest of the 2 months period. And you have to pay that up front or you don't get your utilities. And so I don't understand why they don't do that. It's not consistent across the state between municipalities, but it's a real serious problem. My city used to also do a landlord's agreement where the landlord signs an agreement so that when the tenant moves out, the utilities would then automatically switch into the landlord, so that they knew that the people, who was there and such during the winter, because you cannot turn off the utilities on someone because of lack of payment. But it's a real serious problem across our state. So.
I'm just got a quick question on page 2, subparagraph B. It says shall not require the property owner to contract with the city or town for provision of any of those services. Let's say a municipality did want to do some type of agreement that it's primarily in the name of the renter or the leaseholder, but then it's a contract as well with the property owner as a backup. Should that be allowed? I mean, if the landlord willingly enters into a contract, some municipality says, we're going to, yes, it's a tenant, but just in case, we want to make sure you are the backstop and you are aware you're the backstop and you've contracted. I think the language, it says shall not require. I just wanted your thoughts on that. If a municipality did want to go about having both names, let's say on the recycling contract, and the property owner was agreeable, this says a shall not be required, and there's just no way to go about that. I'm a little worried that in our smaller communities, maybe they don't want to take that step, which is a problem of a one size fits all. In my city, I understand. You guys think about that, let me know. If you want to answer it now or go ahead.
Mr. Chairman, I think that's fair to be a contract between the landlord and the city. That's between two agreeable parties to a contract. So yes, I think that it shouldn't be, shall is pretty strong. I think it's two parties to a contract should be able to agree.
Further questions, Representative Duncan, Representative Clausen.
Thank you, Mr. Chair and Representative Duncan. What about in the case where a landlord might want to make sure has a backup for, say, electric or gas in the middle of the winter, so those services aren't turned off and have a freezing problem? Would there be any issue with this bill interfering with that?
Representative Duncan.
Mr. Chairman, that's not part of this bill. Gas is a different entity all in itself. This is typically city is water, sewer, and those gas is completely a separate, and they do have a backstop already.
One more question. Let's say I'm a very absentee landlord. I don't even live in that town. I've moved to the East Coast, let someone rent my house, and I'm not keeping tabs on them. I mean, the rent check comes usually, we have some lease agreement, but they have left town, left me high and dry. I don't even find out about it till the next month when they haven't paid the rent. I try to call, it takes me a couple more weeks. All of a sudden it's been 2 months. And they left the water running, right? So I do struggle with that part of the bill, that if this is trash, recycling, water, or yes, if it wasn't sewer or trash, I struggle with that part, that there's not some culpability on me as a landlord to make sure I know that, my tenant is gone, or on the behalf of the utility, as soon as that's not utility, well, the city, letting me know as a landlord that no one paid the bill this month. Any thoughts on that?
Mr. Chairman, first of all, I would hope you have a property manager if you live out of state. So bad on you. But that's poor management. Secondly, if your tenant has left town and they're skipping out on their bill, then they owe that. And so the city hopefully has collected 2 months worth of rent as a deposit, correct? And so the city would be out that amount, and they would be able to do small claims or whatever their scenario is. And they would cut whatever the they would have contact and information, cell phone and such. So they would be able to have some sort of contact and tracking for that tenant. Then they would find out, they would send their water department or whatever, because they'd see, wow, that's a pretty high bill. What's going on? Is there a leak? Or maybe the neighbors see water running out the front door. They would go over, they would shut it off. They'd see, I haven't seen anyone there for a while. At least in Torrington, that's what happens. And the neighbor would say, hey, they're not there. They haven't been there in, a few weeks. So they would turn it off, or they would call the landlord at that point. And then the landlord would be responsible from that date forward when they turn it off. That's typically what happens in my neighborhood. But typically they would be on the hook, that tenant would be on the hook until they made contact with the landlord and said, hey, your tenant's gone. And it would be from that day forward. And the landlord would be, with one phone call, say, switch it into my name.
Okay, I'll get a property manager, what you're saying. Representative Blackburn, I know we have lots of people for public comment in the next 20 minutes. Go ahead.
So to answer that real quickly, in the capital city, because I am a landlord, I don't know if you're nice to the water board or not, but they will also let you know when your tenant is behind on their bill. They'll let you know if your water usage is too high. So a landlord that's an absentee landlord wouldn't have a problem like you thought.
All right, for the question, Representative Duncan, if she's not going to go too far, and we're going to bring up Representative Washut. I apparently am the only legislator who forgot today was Camel Day. Oh, apparently my vice chair did too. Representative Washut, welcome to present on House Bill 143.
Thank you, Mr. Chairman. I don't have a lot to offer on this bill, but what I would say is this is a serious problem, and it really has a fairly simple fix. The vast majority of these cases are fixed with a deposit. And we've heard testimony that other communities do collect a deposit. I just can't fathom why a government, especially as large as they have in the capital city, wouldn't be able to develop a process by which to collect a deposit on these properties. So I think it's unjust to the property owner to not only have to pay all these bills that the city could have protected itself against, but also then to not be able to get the utility restored until the bill's paid. So you can't even rent the property to another tenant. Big problem, simple solution. I'm in favor of the bill.
I would say usually when you have these problems, your tenant has left you other issues to worry about as well that cost some money. Representative Roscoe, you have a question for Representative Washut? Come on back. Sure. Go ahead, Representative Roscoe.
Thank you, Mr. Chairman. Representative Wassett or Representative Blackburn, it seems like we're shifting the responsibility from the landowner, though, to the city. And I've always seen it that the landowner puts up, makes his renter pay put up not a bond, but what do you call it, a deposit, so that he's covered his last month's rent and all that, and that's taking care of that. And so you're not shifting this responsibility to the city. That's just the way I do it. So I'm not sure what you think, if that's
thoughts. Yeah, sure. Representative Blackburn.
Okay, Mr. Chairman, Representative Roscoe, I think I understand where you're coming from, but on the other hand, I don't provide the water, I don't provide the sewer, and I don't provide the garbage. I provide a home for them to live in. Thus, I have a contract with them and I have a deposit on that home that they live in. If I provided the water, if I was the water guy and it was my well and I picked up their trash personally and took it to the dump, I would certainly charge them a deposit. That's all we're asking the city to do. This can also save the city of Cheyenne money and other towns, I'm sure. Thank you.
Well, technically right now the landlord is on the hook, right? So it would be the responsibility not only to charge a deposit of rent, but then water, sewer, and everything else. And all of a sudden your deposit's pretty high. Right. Yeah, plus your two. Okay. Anyway, thank you, Representative Washut. I know we have some public comment. Welcome to corporations.
Brooks, it is on green. Oh, push it. Can you hear me now? Hear me now? My name is Brad Brooks. I'm the director for the City of Cheyenne Board of Public Utilities. I am that other utility that everybody's talking about. Hopefully I can enlighten and explain why we have done for over 70 some years, how we've operated. Currently, we are in opposition to this bill, House Bill 143. Again, this bill was brought up back in, I think, 2019 as House Bill 105. It did fail in the third reading in the House. And so currently we have 3 ways that renters actually pay the Board of Public Utilities. A renter they come in. Let me go back one more. We do not, as was correctly stated, charge any deposit for our users. Right now in our city ordinance, it does specifically say that the property owner is responsible for payment of all charges for utility service provided to the property during his ownership. So it specifically said, our heavy hammer, if you would say, that if somebody doesn't pay their bill, we have the ability, as has been mentioned, to go shut off the water. What would happen under this type of bill if this was allowed, because we cannot hold the property owner or the landlord responsible for those services, then basically what would happen is we would be responsible to go after this tenant or renter if they've left to collect this, which I do believe to the city, I would agree with Representative Roscoe that it is asking and adding an extra responsibility onto the utility, that we feel strongly that as a landowner, a landlord, when you make a decision to turn your property into a rental decision, there is certain responsibilities that come along with that. And we feel that one of those is the responsibility of your tenants. To pass that on for us, the City of Cheyenne Board of Public Utilities, will require extra time, effort, money spent to make those collections. We have right now roughly about 50 collections a day that we call people on those type of similar actions. So, we do want everybody to pay their bill, but there is extra expenses that are going to be incurred by the city. We do have brand new software that we can incorporate deposits. It will not be up until probably 2022 of January. Just so you know, that isn't simple. That cost us over $1 million for that software. So it's expensive. It does all of our utility billing a lot. But with the property becoming a rental, we feel that responsibility should stay with the landlord, not passed on to the public utility. That is a burden that I think is being passed on to, bottom line, I can share here with you, that cost to do that business is going to be passed on to our ratepayers. We feel that is something that should be incurred, as was mentioned with deposits. That's something that easily up front can be addressed. There's deposits that are collected by the renter. They could add to their deposit to make up a shortage of any water bill. The other thing we asked, how much do you add on? $200, $300, $400 a month? So we say that prices are getting high and that you're going to charge, and it's going to be overwhelming for a landlord to charge additional deposits. Well, the Board of Public Utilities is going to charge that as well. Ultimately, that resident is going to be getting hit with those deposits. So the other thing, when we have any issues with the water and sewer, the tenant, as was mentioned by somebody here, does not own that water sewer service. That is strictly with the landlord. If there is an issue with a main break, a backup, we don't go to the tenant, we go to the property owner. And that's why we feel that the property owner should solely be responsible for the actions of their tenant. Bottom line, this is what's going to happen if this bill goes through. If I have a rental property, my renter doesn't pay, they skip, there's a water bill out there. Right now, our heavy hand is that we can shut the water off. And we can tell the landlord, we're not going to turn it back on until you pay that bill, whether it's between them or their renter. What this is going to require is that a property owner could call in and said, I'm not responsible for those bills. I want the water turned back on. We're going to start the process all over again. And then the entity or the municipality is going to be responsible for going out and recovering those funds. And we do write off a lot of funds at the city a year on water and sewer bills. And so I just think that this is clearly an area where I sense that we are making different rules or subsidizing rental properties versus our normal property owner. Our normal property owner, if they don't pay their bill, that is something that we have in our city code where we can shut the water off. With a rental property, this would take that authority away, or our ability to be able to collect, because we can't shut that water off. We'd have to turn it back on because we really can't hold the property owner responsible for those undue bills. So those are what I'd like to share. There's two other quick comments I'll make. Making it effective July 2021 is really pretty quick. I think that's only less than 4 months away. So if this was to go through, I think, January of 2022 would be more acceptable. The other thing I did mention, it was mentioned earlier that typically this just relates to water, sewer, sanitation. There is entities in the state, Gillette being one, they provide power, gas, water, electric. So I do know in the last bill that time this came up, natural gas and electric were being put in, and I don't see them mentioned in here. So another question I was wondering is, why is it specific strictly to sanitation, water, and sewer? And with that, I'd be glad to answer any questions. I so appreciate your time.
How many on a, let's say monthly, do you refuse to turn the water back on until the bill's paid? I mean, does that happen frequently, or the threat's there, but you never, I mean, how often do you just say, no, I'm not turning it back on until you pay? It is daily.
It's a daily event. We have an individual that we send out at the end of every day to turn people back on or turn people off, depending on if they paid their bills or if they're delinquent.
You charge an additional fee for that?
We do.
Okay. And then when you said we several times, is we the Board of Public
I
Utilities,
would
or
say
is
we would be
the
the Board of Public Utilities, yeah.
You mentioned there's a city ordinance, so that would be your city council has
City council.
directed you. I'm trying to figure out where the line of authority is.
Yeah,
The board
so,
operates
in
because the
fact-
city council has said you will, or the board operates on their own volition on what to charge?
No, it's basically under city code that we will, yeah.
Representative Duncan.
Thank you, Mr. Chairman. So I have an issue, obviously. Because I'm really confused, because what is different between a tenant and an owner? Because the bottom line is the user of the utility, it doesn't matter whether they're a tenant or an owner, it's the person who is using the utility. That's it. It doesn't matter whether they own the property or whether they rent the property. Ultimately, whoever is the end user of the utility is the end user. So in my particular case, in Torrington, we don't have a problem because they don't care whether you're a tenant or you're an owner. And if you pay your bill, fine. If you don't pay your bill, you get shut off. So they don't care whether you're a tenant or an owner. And so that's what I'm not understanding about your scenario, that you're an owner and you're a distinct difference in class. So help me understand this, because there doesn't seem to be a reason to have a different classification of a person.
Mr. Brooks, if you can.
Yeah, through you, Mr. Chairman, to Representative Duncan. Yes, I would agree. I think we treat, it doesn't matter if you're in or not. The difference here that you stated was that if they don't pay, you shut them off. Sorry. You shut them off. Well, here it's okay. We can shut them off, but we'll have to turn them back on. So we can't use that to shut them off, because the way this law is written is that basically anybody as a property owner or a landlord could say, I want the tenant's gone. They've used funds that are already expended. We got to go after that. But we're going to be required to turn the water back on in order to provide service for the next renter. That's the catch here, is that with the way this is written, we cannot hold the property owner responsible for any undue paid bills. And what we would do right now that is different between a normal resident and say a rentee or a renter is that we have to go over after the renter. We all understand that. But now Brad Brooks is the property owner and say, I understand my renter's gone, but according to this law, I need you to turn the water back on because you can't come after me for those fees. So I'd say that's where the difference would be.
Then Duncan, question?
Thank you, Mr. Chairman. That's my point. In Torrington, we're not putting it at the property, we're putting it at the person.
Okay.
We're attaching it to the person. So our account, yes, there's an account. I, Shelley Duncan, have an account number.
I need you to phrase it as a question, Representative Duncan. It's a question.
Correct.
Okay, go
Yeah,
ahead.
correct. I, Shelley Duncan, have an account number at this particular property. But if I leave and I'm not paying my bill, you have your account number at this particular property. So they're still going to go after me, but there's not going to be a residual dollar figure at this property that's going to be held hostage. Do you see what I'm saying? So you are going to start fresh as long as you don't have an account somewhere else with money. So that's my point, is that the account amount is it's by person. So that's my question. I'm still confused that we're holding accounts per person, per usage versus per property. So how does that, this bill is, I guess, is what I'm seeing. It's not per property, it's per person.
I think, let me correct me if I'm wrong. The problem is in turning the water back on, BOPU would be required to turn the water. They could go after the other person for the money. But the property owner is going to want that water turned back on and saying, not my problem, you go collect the money, but I want the water back on now. The question is, do you have any way to tell a difference between who a property owner is and who a renter is? When they come in to pay the water bill, you require them to tell you, I own this? Well, because the statute said that.
Yes.
Yeah.
Yes.
But in other places, how would you?
I do.
Okay, I know I have 3 other people wish to testify before we adjourn.
Thank you.
Is that, okay, Ms. Gleam, I'm gonna let you in. Is there another mic on somewhere else in this room? Oh, Representative Clifford, you had a question for
I
BOPU?
didn't want to interrupt, but for the Mr. Board of Public
I'll bring him back up in
Utilities.
just a second.
Okay.
Let me have Ms. Gleam.
Can you hear me?
I certainly can. Go ahead.
My name is Julie Gleam. I'm with the Cheyenne Landlords Association. And previous to COVID, most of our members were from Cheyenne. And now that we're in the middle of COVID and our meetings went live on Zoom, we're statewide, so I get comments all over the state. For over 10 years, we have gone to the Cheyenne Board of Public Utilities, the Cheyenne City Council, and then a couple times to the legislature to fix this issue. Mr. Brooks talked about how the landlord is notified when bills aren't being paid and things happen. That simply doesn't always happen. Sometimes the bill gets very high and the landlord's been left in the dark. If this were just about water, it'd be a different story, but it's no longer just about the consumption of water. We have tenants that have gotten more and more clever at how they get their water. One way is that they go to the neighbors and they tap into the neighbor's water system. In every case that this has happened, BOPU has been the first person to find out about it. Rather than contacting the landlord or dealing with it that way, they simply not only turn off the water or fix the water system, but they've been removing the meter. That meter cost over $2,000 for a landlord or homeowner to put back in place. And this has become, this is no longer, and we have other landlords online if we get to them to talk, but this isn't a landlord of just usage issues. It's also an issue of criminal activity, because that is a theft of services, and it's well over $1,000 when it happens. We've had this happen not only on the water, but we've had it happen with electricity as well. And so we need to fix this so that the state of Wyoming stops giving their blessings to criminal activity, because essentially we have somebody that breaks the law, they're able to hold the landlord responsible. The landlord never, ever okayed the breaking of the law. And yet the person that has to pay for it is the landlord. The tenants need to be responsible for their own criminal activity and their own usage water. And as Representative Duncan has said, it is about the person who consumes the water should be paying for the water. It shouldn't be passed on. I've heard about the fix being very simple. Get a deposit. The landlords get a deposit. We all know that. That deposit rarely covers the actual damage, not to mention the water bill. It rarely covers the physical damage to the unit. And for that reason, we would strongly encourage Cheyenne and all utilities to collect the deposit. And if you collect the average of 3 months water, and then you cut off after 2, theoretically that account with time should be enough to cover a missing or an unpaid water bill. So Cheyenne talks about what they're doing now. Well, frankly, it really isn't working. They go to the city for $50 to $250,000 a year to pay on these unpaid water bills, when all along they could have gotten deposits to take care of business themselves. They want to pass on the responsibility to the landlords and who have much less ability to handle these problems, and they end up doing it in court. And I would like to remind this committee that we're not talking about large jumbo corporation landlords. We're talking about mom and pop landlords that have 1 or 2 rentals. They're getting these large utility bills. And not only that, and what Mr. Brooks didn't say is, it is possible we've had in cases where the tenant doesn't pay their water bill, the landlord, and then they ran it up 2 or 3 months, which the Board of Public Utilities knew it was being ran up. But not only do they have to pay that, but if they don't pay it, they run the risk of having their own water at their own residence turned off as well. And so what the landlords have the biggest issue of is Mr. Smith ran up a water bill at 123 Main Street. Mr. Smith moves over to 123 Lincoln Way. He still gets water, and the landlord who did not run up the water bill is now responsible for getting that water bill paid.
So Ms. Gleam, I really sincerely apologize. It's second reading of the budget today, and we have to do budget amendment. I normally let us go 10 more minutes. So we are going to carry the whole bill over to Friday at noon. We'll do it first, Barb. Ms. Gleam, if you're available Friday at noon,
Yes.
we will continue with public comment. I know Mr. Siglin is also on. We have some people here in the audience who wish to testify. So we just ran out of time today, but certainly appreciate it. If you're not available for some reason on Friday at lunch, certainly email me, or we'll find another way to get all your commentary in. So sorry to cut you off. It's just the nature of the legislature on second reading of the budget. But
That's
look forward.
okay.
Okay. And in committee, we will take this bill first up on Friday at lunch during regular scheduled time. And I send, I think, some requests to Bopu and some other people about how the policy works now. So with that, we are adjourned till Friday at lunch.